evening, everybody. I'd like to first echo Kim's respect for the traditional owners of this land and for the distinguished members of this audience, and the latter is a title in which I include you all. Thank you for being here tonight. It was a very great pleasure and a genuine honour to receive the invitation to deliver this year's Francis Burt Oration. I want to thank Kim Lendich, SC, the chair of Francis Burt Chambers, for the invitation. Now, in a happy coincidence, and one I don't think that Kim was aware of when she asked me, my godson happens to be the great-grandson of Sir Francis Burt. So it's a privilege to speak in a forum that honours my godson Benedict's great-grandfather, and of course, one of Western Australia's most distinguished citizens, a jurist of intellect, integrity and vision. In preparing for this lecture, I have enjoyed reading some of Sir Francis Burt's speeches. Sir Francis was not only a builder of legal institutions, but a believer in their deeper purpose, to serve the public, to educate, and to uphold the rule of law with strength and fairness. Sir Francis believed that the law was not some cloistered preserve of the elite, but a living institution, part of the fabric of civic life. He saw the rule of law not as a slogan, but as a discipline, something to be nurtured, defended, and above all, explained clearly and publicly. That belief in the communicative role of law, the idea that the legal profession has a duty not only to interpret the law, but to engage the community in understanding it, feels especially relevant tonight. Because if ever there was an area of law that needs explaining, it's international law. Almost certainly, some of you had to account for what you are doing tonight, perhaps to a colleague, a partner, a spouse, a child. Sorry, I'm going to be a bit late back this evening. Not again, they might have said. Where are you going this time? And of course, you would have had to explain. I'm going to a lecture on international law. Now, here I'm willing to wager that the words international law will have been said using a range of different tones. I like to think that some of you may have said the words international law with a sort of breathless excitement. International law resonates with you. You're fluent in the acronyms. International law's key personalities roll off the tongue. Indeed, you're on first-name terms with them. Did you hear Karim speak at Chatham House? Apparently, Amal was pivotal in persuading the OTP and the PTC to support the ICC arrest warrants. Others will have spoken about international law with a kind of resigned indifference. Ah, yes, international law, that thing I studied briefly in second year before I started doing real law. For you, international law is something that happens in Geneva between people wearing lanyards who say normative a lot. Interesting in theory, but unlikely to come up in chambers next Tuesday. A few of you might have said international law with a bit of a wink and a nod, a raised eyebrow, a half smile, as if you're off to a lecture on the legal status of unicorns. For you, international law is the feng shui of law, more law adjacent, vaguely respectable, but mostly a mix of morality, aesthetics, and wishful thinking. The famous jurisprud, John Austin, would have agreed. He described international law as not law properly so called, but something closer to positive morality. This might have been in 1832, but then again, English scepticism ages like port. Of course, some of you will have said the words international law with a clenched jaw. For you, a lecture on international law is not just indulgent, it's an affront. You're already daring me to say something about Tony Blair as a war criminal, Prime Minister Netanyahu as a genocide heir, or climate change as ecocide. You're hoping I get this over with quickly so you can be the first to get onto the microphone for the Q&A to set the record straight. For this camp, international law isn't just ineffective, it's dangerous. It's basically politics dressed up as principle, a threat to sovereignty concocted in the soft power laboratories of Geneva, The Hague, or the nerve centre of European human rights, Strasbourg. Now, this discussion of tone is not merely a distraction from getting down to the business of the lecture. On the contrary, tone is revealing. It shows us how we really think about international law, before we've even had a time to reason it out. It exposes a potential tension between our mindset about the rule of law in the domestic setting and its international counterpart. Many of us in this room are lawyers. Our profession is deeply engaged and professionally invested in upholding the rule of law. And as those of us who have studied jurisprudence will know, what makes law work, what makes it more than just an institutional ideal, is a particular mindset, a shared disposition among lawyers, judges, and citizens that law is not simply a gunman's threat or a formality, but a source of obligation. H.L.A. Hart, one of Oxford's finest legal minds, called this the internal point of view, the idea that legal rules are not merely habits of obedience or external constraints, but standards that those within the system treat as binding. What I mean to say is that the tone that we adopt as lawyers about the law is not just incidental. For law to function as more than coercion or custom, it must be accompanied by a professional mindset that treats legal norms not just as commands to be obeyed, but as standards to be internalised. The rule of law, in other words, is sustained not just by institutions, but by orientation, by the way we as lawyers habitually think about and speak about law's authority. In Western Australia, we take it for granted that no one is above the law, not politicians, not judges, not police commissioners. If a politician is charged with an offence, we expect them to stand trial, to receive due process, and to accept the verdict of the court. This is what A.V. Dicey called the first great principle of the rule of law, the supremacy of law, the need for political decision-making to take place according to law. The second, equally important, was legal equality, that every official, no matter how exalted, is subject to the ordinary courts, just like any citizen. If a politician is charged with corruption or misconduct in public office, or even just found to have misused their powers, our legal mindset is, well, no one is above the law. We might speculate about political motivations for prosecutions. We might query why X-politician has been singled out and not why. We might roll our eyes at the media coverage, but we don't, as a rule, question whether the law itself should apply to them. We don't doubt the authority of the court, whether it's the Magistrates' Court in Karratha or this Supreme Court just off St George's Terrace. But now, let's change the venue. Suppose the same prosecution, abuse of power, unlawful violence, harm, is taking place not in Perth, but in The Hague. The accused is not a state politician, but a president, a general, a rebel commander. The charges are not corruption, but genocide, crimes against humanity, war crimes, and suddenly the tone shifts. The question comes faster and sharper. We move quickly, sometimes instinctively, from no one is above the law to this is victor's justice, this is neo-colonialism, this is a show trial, this is lawfare. The rule of law mindset, so ingrained in domestic practice, becomes unsteady. Why is that? First, I should pause to explain what we're talking about when we speak of international criminal law. At its heart, international criminal law is a legal framework that does something conceptually simple, but institutionally radical. It holds individuals, not states, criminally responsible for acts of mass atrocity, genocide, war crimes, crimes against humanity, aggression, the latter in a more qualified way. International criminal law's foundations are often traced to Nuremberg. The trial of Nazi leaders was seismic. The law's declaration that political power does not grant impunity from individual responsibility. But in the decades that followed, international criminal law existed more as an aspiration than a system. There were occasional prosecutions, the Eichmann trial in Jerusalem, the Barbie trial in France, but nothing resembling a functioning or coherent legal order. That changed, and quite late in the day, in the 1990s. The atrocities in Rwanda and the former Yugoslavia forced a reckoning. The international community, still reeling from the failures of diplomacy in the face of 2 genocides, turned to law. 2 ad hoc tribunals were created, and from their example emerged something more permanent, the International Criminal Court. The ICC opened its doors in 2002. It was the product of a treaty, the Rome Statute, a multilateral agreement among now 125 states that certain crimes are of concern to all humanity and that no state can claim the right to shield perpetrators. Today, the ICC has jurisdiction over the core crimes of genocide, war crimes, and crimes against humanity, but with a twist that's often misunderstood. I don't mention aggression here because it's subject to a slightly different jurisdictional framework. But in relation to genocide, war crimes, and crimes against humanity, the court's jurisdiction is triggered in one of three ways. First, when the accused is a national of a state party. Secondly, when the alleged crime takes place on the territory of a state party. Or third, when the UN Security Council refers a situation to the court. This means that even if a state is not a party to the Rome Statute, the US, for example, or Russia, or Israel, its nationals can still come within the court's jurisdiction if their conduct takes place on the territory of a state that is a party. That is not a loophole. It reflects a basic and widely accepted principle of criminal jurisdiction, territoriality. If I travel to another country and commit a crime there, I am subject to that country's laws, regardless of whether my home state recognises its courts. The ICC operates on the same principles. Its jurisdiction follows the location of the crime, not just the nationality of the accused. So far, the ICC has indicted around 70 people. It has convicted 8 individuals for core crimes, acquitted 4. All of those convicted have been non-state actors, all from African states. This has understandably raised eyebrows. Why only Africa? Why only rebel leaders, not any government officials? The court has done too little. It has been timid, selective, complicit in the global imbalance of power. But more recently, the complaints have changed pitch. In March 2023, the ICC issued an arrest warrant for President Vladimir Putin for the forced deportation of Ukrainian children. In November 2024, it issued arrest warrants for Prime Minister Netanyahu, former Israeli Defense Minister Yoav Gallant, and senior Hamas leaders. Now the charge is not that the court is doing too little, but that it is doing too much. It is accused of inserting itself into live conflicts, meddling in war, threatening sovereignty. And the backlash has gone beyond criticism. Many of you will know, though some of you may not, that the Trump administration has imposed sanctions against the prosecutor of the International Criminal Court and 4 of its judges. Under a US executive order, any US corporation, NGO worker, academic, intern, or other US citizen offering support or advice to the ICC risks up to 20 years in prison and/or $1 million fine. For the ICC prosecutor, a British citizen, this has led to his NatWest bank account being frozen in the UK, his Microsoft email account being shut down, and the travel of him and his family to the US has been banned. Not only is the rule of international law not being respected, it has been criminalised. We would not accept this if it was done to prosecutors or judges enforcing criminal law in Western Australia. Why do we accept it when it is done to prosecutors and judges enforcing international criminal law? The answer, I think, lies in a fundamental discomfort, one that sits at the heart of this evening's lecture. In our domestic legal tradition, we are trained to imagine law and politics as distinct spheres. Law earns its legitimacy by rising above power struggles, not intervening in them. It constrains individuals. It does not challenge state power. Especially in criminal law, we expect law to be neutral, apolitical, restrained. Law's authority depends on its distance from the fray. But international criminal law cannot keep that distance. It does not simply operate in a political context, it intervenes in it. It does not just constrain state power, it sometimes seeks to displace it. It declares that certain political decisions are not merely wrong, mistaken, or regrettable, but criminal. That some leaders do not just abuse office, but violate a deeper moral and legal compact with humanity itself. This is what makes international criminal law feel so radical and unsettling. It is not just the law's content. International criminal law seeks to reorder the terms of political legitimacy. It proposes a legal system that is not anchored in a single territory, a single demos, or a single government, but in something far more diffuse, the idea of a shared human conscience. In my academic work, to save you reading it, I've described law as a triangle composed of community, purpose, and authority. In stable domestic legal systems, these elements are settled. So let's take the recent case of the State of Victoria and Erin Patterson. Here, the case name itself signals the political community on whose behalf the case is brought, the State of Victoria. The purpose is equally uncontroversial. That community has agreed, firmly and for some time now, that murder crosses a legal and moral line. And the authority is clear: a Supreme Court judge, a jury of peers, and a criminal process determined with the legitimate authority that a beef Wellington crossed the line from culinary faux pas to murder weapon. No exception even for in-laws. In short, the triangle holds. And because it holds, the law functions quietly, effectively, without existential controversy. International criminal law, by contrast, is still assembling its triangle. Its community is plural and unsettled, less a cohesive polity than an aspirational construct we call the international community. I've put that in inverted commas in my written version of the speech. Its purpose is narrower than that of most domestic systems. Not general peace or social order, but recognition of a narrow set of standards prohibiting certain conduct: genocide, crimes against humanity, war crimes. Its authority remains a work in progress, granted by states piecemeal, hesitantly, sometimes revoked when it cuts too close to power. It is this fluidity of community, purpose, authority that gives international criminal law both its promise and its precarity. It lives in tension as states and other actors have through history sought to locate the balance between the international and the domestic, between what is deemed necessary in the pursuit of security and what is never permissible, even in war, between the moral clarity of the law and the entrenched weight of power. But rather than wrestle with that complexity, we often reach for something simpler. We caricature international criminal law, not necessarily because we misunderstand it, but because we sense correctly that it is doing something profound. It is not just punishing war crimes, it is redrawing the boundaries of political legitimacy. It is claiming that law, not the battlefield, not the ballot box, is the supreme language of accountability. That is a bold claim. And for those who operate in traditional seats of power, capitals, command posts, closed-door summits, it is also a threatening one. The caricature that emerges are not just careless distortions. They are acts of defence. They dismiss international criminal law, not to improve it, but to deny its authority altogether. And this brings us back to tone. Those bristling, bemused, bored, or breathless responses to international criminal law are not just social quirks. They are signals, clues to the deeper narratives we tell about who gets to exercise power, who is subject to law, and whether there is any law above the state. These caricatures matter because the fate of international criminal law will not be determined only by treaties or tribunals, but by belief. The fate of international criminal law in large part depends on whether we, as lawyers, as citizens, are willing to treat this project, still fragile, still forming, as the foundations of an accepted legal order. In the final part of this lecture, I want to examine 4 common caricatures of international criminal law. Each in its own way reflects an attempt to deny one of the elements of this emerging criminal justice system, either its community, its purpose, or its authority. The first caricature casts international criminal law as actively dangerous, a direct threat to sovereign authority. This critique strikes at the very heart of the legal triangle. It denies the existence of any legitimate political community beyond the state. Now, according to this critique, international criminal law and the International Criminal Court isn't really a court. It's a hostile alien structure, a sort of Death Star of liberal legalism, vast, officious, looming in low orbit, threatening to vaporise the sovereignty of domestic states. The court's prosecutor, Karim Khan, and let's face it, even his name sounds like a Star Wars villain, pretends to dabble in the prosecution of nameless bit-part warlords from faraway conflicts. But his real target, the free world. Armed with his subpoenas, he advances relentlessly toward US generals and Israeli ministers ready to obliterate constitutional government with a single Article 15 investigation. And behind Darth Khan, of course, sits the judges, Emperor Palpatines, from another galaxy altogether. From their shadowy chambers, robed in judicial cloaks as black as the void, they murmur in solemn, strangely accented tones about Yuskogans and gravity thresholds. But what they're really after is control. Now, if you think I'm exaggerating the tone, I haven't yet introduced our Jedi Knight, John Bolton. It's the perfect name for our constitutional crusader, though you may know him better as President Trump's former national security advisor. In a 2018 speech to the Federalist Society, John Bolton laid out his position plainly. And I'm quoting from his speech. "The hard men of history are not deterred by fantasies of international law such as the ICC. The idea that faraway bureaucrats and robed judges would strike fear into the hearts of Saddam Hussein, Hitler, Stalin, and Gaddafi is preposterous, even cruel. Time and again, history has proven that the only deterrent to evil and atrocity is the righteous might of the United States and its allies. We will ban the ICC's judges and prosecutors from entering the United States. We will sanction their funds in the US financial system, and we will prosecute them in the US criminal system. We will let the ICC die on its own. After all, for all intents and purposes, the ICC is already dead to us." This critique isn't just about fear of foreign courts. It's about a fundamental rejection of the idea that political legitimacy or legal accountability might come from outside the state. This is the caricature that clings most tightly to sovereignty. Sovereignty as the ultimate shield. But what is sovereignty, really? We speak of it quite often as something that we can hold in our hands. Where is Australia's sovereignty? Is it stored in a filing cabinet in Canberra, nestled in the clasp of Prime Minister Albanese's briefcase, floating somewhere off the coast of Rottnest? Of course not. Sovereignty is a fiction, a powerful one, but a fiction nevertheless. And like all legal fictions, it can be reimagined. One of the most significant achievements of international law over the last century has been to transform our understanding of sovereignty from an absolute license to a framework of rights and responsibilities. In the traditional Westphalian model, sovereignty was absolute. The state was its own master, and what happened within its borders was nobody else's business. But international law has steadily dismantled that model. Today, states are bound by treaty obligations, constrained by international courts, and subject to a certain narrow body of norms from which no derogation is permitted. Peremptory norms, or what we describe as Yuskogans rules, prohibiting genocide, torture, aggression, apartheid, and so on. This isn't just legal theory. These are binding obligations enforced by a different kind of political community, the international community. And it is this community that now determines the outer limits of lawful state conduct. International criminal law makes that challenge explicit. It takes the quiet presumptions of modern international law and gives them teeth. It doesn't just regulate state behaviour, it holds individuals accountable for the most egregious violations. It strips away immunity for leaders. It insists that certain crimes of a certain gravity concern all humanity, and that where domestic systems fail, international justice will step in. That is the logic between a legal principle known as complementarity, a cornerstone of the Rome Statute. This legal principle gives states primary responsibility to investigate and prosecute international crimes. But, and this is the shift, where states fail to do so, it is the duty of the International Criminal Court to step in. If one caricature sees the ICC as a tyrannical Death Star of international law, another sees it as something altogether more pitiable, ineffectual, toothless, out of its depth. This view, holds that international criminal law is a grandiose fantasy, a well-intentioned but essentially performative exercise, issuing unenforceable legal declarations while war crimes rage on. In discussing this caricature, I'm reminded of a conversation I had with Alexander Downer, Australia's then Foreign Minister in the wake of the Iraq War. The year before, I had authored the legal advice for the federal opposition, advising that the use of force against Iraq would be unlawful under international law. In 2004, he met me in his office. Partway through our conversation about the relevance or irrelevance of international law, I remember him rising from his chair, and at this point, if I recall correctly, he did a practice golf swing as he said, "Never let process get in the way of the right outcome." It was an extraordinary admission, a 9-iron through the rule of law. The right outcome, in his view, had already been decided. Law was, at best, ornamental, a rhetorical advice to justify action, not to constrain it. This instinct that law must yield to political necessity runs deep, and it animates much of the caricature of international criminal law as ineffectual. The assumption is that law must not interfere with hard choices made in war, crisis, or emergency, particularly when those choices serve a state's national interest. But this misunderstands what international law is and how it is made. International criminal law is not a speculative moral ideal. It's rooted in decades, sometimes centuries, of state practice, treaty law, jurisprudence, and political consensus, and it reflects the collective determination that certain forms of violence lie beyond what states may lawfully do, no matter the pressures of realpolitik. Genocide, war crimes, crimes against humanity, aggression. These are not merely regrettable outcomes of war. They are prohibited, not just because they're wrong, but because we have learnt that this conduct threatens the basic structure of international order. The line between what is permitted and what is criminal exists precisely to restrain power in circumstances where the temptation is to override law in the name of necessity, vengeance, or national interest. Then there is the second critique implied in Downer's response. Even if the law does demand restraint, who's going to make me? Who's going to enforce it? It is certainly true that international criminal law has an enforcement problem. The Italian jurist and the first president of the Yugoslav Tribunal, Antonio Cassese, described international criminal tribunals as a giant without arms or legs, entirely dependent on state machinery to execute warrants, arrest fugitives, enforce judgments. That's not the fault of the law. That's a deliberate design imposed by its state architects, state actors who were willing to impose the appearance of justice, but not always its operation. Still, to judge international criminal law's purpose solely by reference to punishment is to miss the point. The imprisonment of individuals may be one outcome of international criminal law, but it is not the only or even the primary measure of its success. Until states decide or are compelled to create reliable mechanisms for consistent enforcement, international criminal law still has critical work to do. Its power lies not just in who it punishes, but in what it affirms, the standards it sets, the evidence it gathers, the objective determinations it makes. Let me talk to you about the Tokyo Women's Tribunal. This tribunal was established in 2000 to address the crimes committed against so-called comfort women, the tens of thousands of women forced into sexual slavery by the Japanese military during World War II. The crimes of sexual slavery and forced prostitution were not among the crimes prosecuted at the original Tokyo Tribunal in 1945. These women returned to their communities after the war not as survivors, but as pariahs, shamed, some of them cast out of their communities. What had happened to them was never acknowledged as criminal. The Tokyo Women's Tribunal was established by a civil society coalition in 2000. It had no powers of arrest. It could not imprison. But it was presided over by respected judges, including Gabrielle Kirk-MacDonald, former president of the Rwanda and Yugoslav tribunals. It followed rigorous procedures. Experts testified. Survivors gave evidence. 2 former Japanese soldiers appeared in person. And in the end, it handed down a judgment. Over 2,000 people turned out to hear the judgment being handed down. It was broadcast by Japan's national broadcaster, NHK. This tribunal could not jail a single perpetrator, but it did something that for many of these women mattered more. It determined that what had happened to them was a crime, not an unfortunate consequence of war, not a dishonour for which they shared partial responsibility. What had happened to them was recognised and declared in a legal written judgment to be a violation of international law. This caricature that international criminal law is ineffectual doesn't just underestimate international criminal law, it misunderstands its whole purpose. It assumes law exists only to punish, and that if it fails to imprison, it's failed entirely. But the purpose of international criminal law has always been broader. It's about recognising legal standards of political conduct. It's about deterrence. It's about protecting communities. It's about giving victims a voice. It's about setting a record, a historical and legal account that will outlast the perpetrators and sometimes even the states that protected them. Now, time, I turn to you. Let's turn our gaze a little closer to home. A third caricature paints international criminal law not as dangerous or impotent, but as irrelevant. The law of other people, other places, something that happens in distant courtrooms at The Hague, argued by UN lawyers against rebel commanders from failed states, something for Africa, maybe for Europe, but not for here. The problem with this mindset is that it gets the architecture entirely backwards. The International Criminal Court was never designed to be the sole forum for accountability. In fact, the ICC was created as a court of last resort. According to the doctrine of complementarity that I referred to before, the real weight of international criminal justice is intended to be borne by domestic courts. It is domestic courts that bear the primary obligation to investigate and prosecute international crimes, and it is only when they are unable or unwilling to do so that the ICC steps in. This obligation includes, not incidentally but fundamentally, the capacity to exercise universal jurisdiction. Now, this is a legal principle that some crimes are so grave that they can be prosecuted by any state, regardless of where they occurred or who committed them. In these moments, a domestic court becomes something more, an agent not merely of domestic justice, but of the international legal order. It prosecutes not just in the name of its citizens, but in the name of a wider international community. And yet that responsibility is frequently misunderstood, or more often quietly avoided. I spent several months of my life in 2015 and 2016 observing the Kumar Lama trial in the United Kingdom, only the third universal jurisdiction trial ever held in British history. Colonel Lama, a colonel in the Royal Nepalese Army, was prosecuted on 2 counts of torture committed during Nepal's civil war. The legal basis was sound, the case had potential, but the execution faltered. The prosecutor began his address to the jury as if reading from a bygone fairy tale. This is a story, he said, of what happened a long time ago to 2 men in a country which is far, far away. It's hard to imagine a more perfect articulation of the very caricature we're discussing, a trial of distance, of irrelevance, as if the case had landed in the court by clerical error, as if it didn't belong. And indeed, the trial unravelled. The presiding judge dismissed the jury with the words, "It is relatively rare for so many witnesses to require interpreters, and indeed for so many problems to arise in one case." The failure was as much one of mindset as of law, a refusal to understand that universal jurisdiction trials are not ordinary domestic prosecutions. They are not exercises in local criminal governance. They are acts of global legal responsibility. That requires not abandoning due process or domestic procedure, but recognising the distinctive community, purpose, and authority that animate international criminal law. By contrast, some states are rising to that challenge. Over 20 states, and this does include the UK, have created dedicated war crimes units. They are staffing prosecutors fluent in the jurisprudence of international tribunals. They are training judges in international criminal procedure. Some, like Germany and the Netherlands, have begun creating specialised international crimes chambers, domestic courts explicitly designed to serve international justice. To date, Australia has completed only one international criminal trial, in 1993, the case against Ivan Polyakovich, an alleged Nazi collaborator accused of participating in the execution of civilians during the Second World War. He was ultimately acquitted. And yet our region, Asia and the Pacific, remains one of the most underserved by international criminal justice. Many countries in our neighbourhood are not party to the ICC. There are few regional accountability mechanisms, and as we've seen in contexts like Myanmar, Sri Lanka, and the Philippines, serious violations have occurred without consequence. This courtroom, this legal community, has a role to play. Australia is by no means a legal backwater. It is home to respected Supreme Courts, a vibrant bar, and a public committed to the rule of law. But to sustain that rule of law in a globalised world, we must understand that accountability doesn't stop at the shoreline. If we wish to uphold human dignity abroad with the same vigour as we do at home, we must accept that atrocity crimes, even those committed far, far away, are not someone else's problem. There is one final caricature worth discussing, and this, in some respects, is the most difficult one. Where some critics see international criminal law as dangerous, impotent, or irrelevant, others place an extraordinary faith in its messianic potential. I'm reminded of a terrible poster for a film-length documentary on the ICC called The Prosecutor. It depicts the former prosecutor, Luis Moreno Ocampo, in a white suit descending from a helicopter into an African landscape like some kind of legal Gabriel. For this camp, international criminal law is the answer to everything, a kind of moral superpower, a corrective to global failure. The ICC on this view will purify nations, reconcile warring parties, prevent future atrocities, and bring world peace. Nowhere is this tendency more evident or more emotionally charged than in the context of the war in Gaza. In November last year, the ICC prosecutor applied for arrest warrants against both Israeli and Hamas leaders, alleging war crimes and crimes against humanity. For some, this was an overdue reckoning, the law stepping in where geopolitics had failed. For others, it was a betrayal, lawfare, an unholy equivalence between a democratic state and a terrorist group. For yet others, it was just another hollow gesture, toothless in the face of real power. In all of this, international criminal law became the receptacle for something much heavier than it was ever built to carry. Rage, grief, political frustration, all were poured into a legal vessel with the expectation that it would somehow deliver resolution, even redemption. But international criminal law cannot bear that weight. International criminal law is not peacekeeping. It is not humanitarian relief. It is not a ceasefire. It does not halt bombings, evacuate civilians, or negotiate prisoner exchanges. It does not end wars. It follows them, slowly, retrospectively, through cautious, contested acts of fact-finding and adjudication. It might be worth concluding with an explanation of what the ICC is doing in relation to the Gaza conflict and why it has the authority to do this. The ICC has jurisdiction over alleged crimes committed in Gaza, the West Bank, and East Jerusalem. This is on the basis that Palestine was accepted as a state party to the Rome Statute in 2015. Although Israel is not a party to the Rome Statute, this does not immunise its nationals from ICC investigation. As discussed previously, the court's jurisdiction applies to the territory of the state party, in this case Palestine, not the nationality of the accused. This is a well-established principle in international criminal law. In May 2024, ICC prosecutor Karim Khan announced that he had applied for arrest warrants against 3 Hamas leaders and 2 Israeli officials, Prime Minister Netanyahu and former Defence Minister Yoav Gallant. The charge includes war crimes and crimes against humanity. For Hamas, the allegations centre on the October 7 attacks, hostage-taking, and acts of sexual violence. For Israeli officials, the focus is on the use of starvation as a method of warfare. Under Article 27 of the Rome Statute, no individual, not even a head of state or senior official, is immune from prosecution for international crimes. That principle is clear. Its enforcement, however, is slower and more uncertain. There is credible evidence that 3 named Hamas leaders have been killed. Arrests of Prime Minister Netanyahu or Yoav Gallant are unlikely unless they travel to a state party willing to execute the warrants. In Prime Minister Netanyahu's case, the practical likelihood of arrest is slim, so long as he remains in power, both because of the protection of his office and the diplomatic cost to any state executing the arrest warrant. That said, the political and diplomatic consequences of the arrest warrants are significant. Travel is constrained, reputation is damaged, and domestic courts in other jurisdictions could, in theory, pick up cases against these individuals and other Israeli officials and Hamas insurgents under the principle of universal jurisdiction. There is no statute of limitations in relation to these crimes. In the meantime, in Gaza, international criminal law can and should do what it was designed to do: draw legal lines around conduct that crosses the threshold into atrocity. It can clarify the law. It can affirm the humanity of victims. It can send a signal to the world and to history that even in war there are rules, and those rules bind everyone: soldier and rebel, terrorist and prime minister, victor and vanquished alike. But let us be clear, international criminal law cannot stop the atrocity. No other state wields the military power, the territorial control, or the strategic leverage to end the violence against people in Gaza. No international arrest warrant will carry as much consequence in the immediate term as a single decision by the Israeli cabinet to change course. And that, perhaps, is where we must end. Not with a legal fantasy, but with a legal reminder. International criminal law is not the whole answer, but it is part of it. It is not a panacea, but it is a pressure point, a frame, even a mirror if we're willing to face it. It tells us something about what the world condemns and what it still permits. It brings law to bear on violence, not always successfully, not always fairly, but with a clarity that politics alone cannot provide. In a world that often feels like it's spinning out of control, everything, everywhere, all at once, international criminal law does not promise perfection. It promises something more modest and more urgent: the discipline of accountability, the objectivity to name wrongs, the resolve to trace violence back to its authors, and the insistence, even if only in principle, even if only after the fact, that power comes with responsibility. And that, in the end, is not someone else's business. That's the business of the law. It's our business. Thank you.